Hi, this is Dr. Scott Young, and today we're going to get into a little of the Chevron Doctrine, but something that people get bothered about all the time, I understand, is HOAs. In NESARA, will the HOAs go away? I'm going to show you how this actually works with it too. So let's bring in this little video. This is from a I-team recovery, I-team kind of situation with it too. Kind of interesting, and then we'll show you a little bit about how crazy this is.
Told you recently about a new state law preventing homeowners associations from banning pickup trucks and work trucks from parking in driveways. That law, Wendy, just took effect.
Yeah, that's right. But since then, Sarasota homeowners reached out to investigator Adam Walser saying their HOA does not plan to change. New tonight, Adam breaks down why the association is still enforcing.
Okay, remember, understand what this is. A HOA has a rule and regulation that you can't have work trucks in this particular neighborhood on your driveway. No, there's so many things wrong with this. It's not funny. I mean, obviously they don't like it. It looks crappy or whatever, They're talking about during the nighttime hours after 5 o'clock. They're not talking about during the day when someone might be working on something, but we're talking about nighttime hours here. Now, the county, or specifically the state, actually overturned some of this stuff, and we'll explain. This is a way that HOAs are actually going to be flushed through the wash. People talk about how HOAs are going to go away. No, they're not going to go away, because who's going to mow the lawns and who's going to take care of frankly, someone, trashing their house, having a broken down house, and then everyone else goes, I can't sell our house because you've got crack house over here, a trashed house. So HOAs are trying to make sure that, things are overall beautified, but they have to go within the law. Watch how this actually plays out. It's very interesting.
The parking rules despite this new law.
Ryan McIntyre, who goes by Mac, loves his 2014 Chevy Silverado pickup.
It's functional, hauling things most of all. Also is the extended cab, because I do have a wife and daughter.
But his truck doesn't easily fit into his garage, and
I cannot park my own truck in my own driveway.
His subdivision, The Meadows, doesn't allow pickup trucks or commercial vehicles in their driveways between 11 p.m. and 5 a.m. based on rules written in 1976, before Jimmy Carter first took office. Violators caught by the association's nightly safety patrol face warning letters, fines, and can be towed out of their own driveways. Mac agreed to the rules when he moved into the neighborhood.
Now, just think about that for a second. Towed out of his driveway. I was wrong. It was 11 p.m. to 5 a.m. I mean, they're basically talking about nighttime hours. Why would you care what truck is in your driveway? It boggles my mind with this stuff.
Neighborhood in 2019, but hoped a new law would change that.
You can imagine how ecstatic I was when I heard that I could park it in my own house.
Mac and his wife now make twice daily trips to drop off and pick up his truck at a fenced-in lot our odometer shows is 0.8 of a mile from his home. He and his neighbors pay $500 per vehicle per year to park there.
We all know each other. We see each other every night and every morning.
If you come back at night, it's full. Everybody's paying to park in here.
Melissa Syatt lives on the opposite side of the 1,600-acre neighborhood.
The schlepping, the back and forth, it's hot, it's a lot.
She runs a mobile aesthetics business out of a $200,000 custom Mercedes van.
I've got my own power, water, everything.
Her husband also parks a pickup in the lot. Melissa welcomed the new law, which says, quote, Homeowners Association documents, including declarations of covenants, articles of incorporation, or bylaws, may not preclude a property owner or a tenant, a guest, or an invitee from parking his or her personal vehicle, including a pickup truck, in the property owner's driveway.
Now, think about that for a second. A law, and we're going to talk about the difference of laws, and I'm going to we're talking about laws versus rules and regs, okay? That the state of Florida decided to pass a law. And we'll get into what that means a little bit more in a second, okay?
I thought it was for everybody. We got so excited about it when it, got signed, and we thought, great, this is going to save us $1,000 a year.
$1,000 a year. So basically 80 bucks a month that they're having to park when they actually have a driveway that could actually park everything, or, afford the parking capability, right?
And yeah, that's not happening.
Meadows residents got this email days before the law went into effect saying, quote, all current parking rules and regulations will remain the same.
They got ahead of it and said, no, we're going to keep everything the same way. So we're ended up with more questions than answers at this point.
They've also sent out reminders after the law went into effect. The general manager for the Meadows Community Association declined an on-camera interview, but said in an email that the application of the new law depends on the governing language of the community association and the time it was recorded. The email referred to something called Kaufman language.
Some restrictions have what's known as Kaufman language, which was sort of a famous case.
Attorney John Ellis says some HOAs incorporate the language as amended from time to time in their bylaws and other documents.
That's indicating if the legislature changes the statute, that would apply. Most homeowners associations don't have that language,
including the Meadows. Both Mac and Melissa plan to abide by the existing rules.
We don't feel like we have a voice, so we don't know really what to do.
But they hope someone will challenge them.
It got the governor to sign it into law. So I cannot be the only one with this concern.
Okay, so let's get into this a hair, because you got to see the struggle. First off, they don't feel like they have a voice. Enter the Chevron Deference or the Chevron Doctrine, okay? What the Chevron Doctrine is it was Chevron USA. This is done in the early 80s, so it's basically a 40-year-old law, or a court case. I want you to catch what I mean. I'm doing this wrong. It is a court case that allowed these three-letter agencies and all of these other crazy little quasi-rule agencies to create things that, and what they had to be is they created something to address an issue, and it had to be reasonable. Now, it might be a little hard. I'm going to pull me off the screen. Bring me back on here. I want to show you another one. This is a poster named Ariel. He's got really interesting stuff. Follow him. I would love to see you do that. Under Chevron, agencies could essentially both make the law, interpret the law, and enforce the law. Both Republicans and Democrats have allowed this to go on for 40 years. The same people that allowed the election in 2020, COVID, blah, 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 Mar-a-Lago, blah, 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 they never, and this is one of the reasons why they didn't like Massey, because Massey was pushing all of their issues. They create these fees, penalties, flags, strikes, seizing, all of this kind of stuff to, and it's created by agencies who don't have the right to create laws. Let's back up for a second and let's understand, and I have it on the bottom here, what in the world are we talking about? Okay, let's say I had a name badge, okay? And let's just say it's this guy's name badge here, and you're going to look at it and go, okay, let's just say I had a name badge that everyone in my company, I said they had to wear this. Okay, so you need to wear your name badge, and it needs to be in red. Because I create red name badges for whatever reason that might be, right? And I say you got to wear that every single day. But you say, well, I really want a purple name badge. In essence, I'm going to cover over this thing. I want the purple one instead of the red. Why? Because I'm so against red. It offends my religion, or it offends my I hate, for instance, in Oklahoma, there's OU that is red, and OSU that is orange. One of the things that we know in marketing is that we never utilize those. So we actually use a purple color. Well, that is from Wichita State, but it doesn't affect, or excuse me, Kansas State. It doesn't affect people in Oklahoma. See, colors actually have a perception in there, right? Let's just say in that same circumstance, red. Let's give you an example here. Here's a red color, right? And let's just say that Scott was making every single color in red because I was so partial with it. And by the way, I kind of like red. Let's just say that was the case. Now, the person wears the name badge as long as I say they work there. They have the name badge, so they have to wear that. It's called a rules and regulation, or a policy procedure. No different, right? It's created arbitrarily by me. And why do I ask that people do this? It's because I want you to be identified as a company employee, or I'm saying that I want our patients to be able to understand this is who is taking care of you. Like, I mean, it happens all the time. Well, it's a woman and she has short hair, or whatever they might say about her, right? They say, if we had a name badge, for instance, well, you'd know it was Dr. So-and-so or Joey so-and-so, whatever that might be, because then you're not, saying it's misidentifying that particular person. So we know who actually said that to you and addressed that concern that you might have, right? It's a reasonable statement to have. So as long as you work for Scott, and I say you have to wear name badges. By the way, I don't do that. But let's say you had to wear name badges. Then what happens is that you're underneath the rules and policies that we do it. Now, if let's say you stop wearing your name badge, or you want to get all sideways with me, you have two choices. Let's say I'm not gonna bow on that one. As the business owner, I don't want to bow on that particular thing. You have a couple choices. It was reasonable to do. There's nothing in the laws. This is the big key. There's nothing in the laws that says, you have to wear this name badge. I didn't ask the person to wear the name badge and wear scantily clothed, stupid stuff, right? Or be naked while they're wearing a name badge. That's unreasonable. That is illegal, right? I don't like have them, because let's say I had no tooth. I say you have to knock your front tooth out to be like all of us here, right? That's an unreasonable kind of response. That's where Chevron was actually brought in as an idea. Now, again, rules and regulations. But let's juxtapose or change our idea to what a law is. In a legislator, so in a state house and a state senate, the state house will write in this particular, and under this case, that you cannot restrict a private owner in their own house from not having a truck in their house, right? I mean, just in their driveway. And you're going, okay. And here's what happens. The House creates it. The Senate might adjust the wording a little bit, passes it, and then it goes up to the governor. And the governor, let's say, and obviously DeSantis signed that particular law. It's not a rule and regulation. And you say, wait a second. Therefore, if I have rules and regs, like in this
Team
same
investigator
particular conversation that it happens over here, let's go backward over a space
The subdivision, the Meadows, doesn't allow pickup trucks or commercial vehicles in their.
And what they're saying is that they don't allow it. We're talking about a regulation. But when a regulation jumps against a law, it is illegal. Therefore, they are following an illegal thing. And it comes from this conversation of the Chevron, the Chevron deference or the Chevron doctrine. So we have had for nearly a generation this particular thing of a rule, of rules that become laws. And it is such the difficult conversation that we've had. And one of the things that I've asked this question over and over again, how do we get rid of some of these sick things? Like this thing that people walk around wearing and required it as a requirement or as a mandate. Is it reasonable to require that? What if I have troubles with breathing? By the way, I'm a person that has an issue with lungs. There's a lot of things people want to talk to me about it and give me their homeopathic remedies with this too. But I can't breathe with those things on. I have a big trouble. What if I go, you know what, we have these other things with this little jabby thing, and I'm not going to take that because it would cause problems for me, or I religiously don't agree with that viewpoint. This is where we get back to the laws versus the regs. And here's the thing. We have these idiots like Como up in New York State, who's out of the state, and he said, well, we took these rules and regs and we were trying to just apply them correctly for people. And I go, no, you didn't. You didn't try to do that correctly for people. You tried to bully them into that viewpoint. And they actually closed businesses. So they used a rule and a reg to close a business. This happens, and you go, why is all this stuff happening? You can get mad at the circumstance, or you can kind of see with deeper lens that the white hats are in the middle of this, changing the NESARA piece. NESARA talks about going into a time frame where we are constitutional in nature in our laws. It means instead of a judge utilizing a Chevron Doctrine defense point, a Chevron deference defense point, and saying, well, it was reasonable. And so here's what they do, is they utilize these things as weapons. Like in 1984, which is around the time frame when this thing came, actually it was the time frame it came in, they used the Chevron Doctrine to wield power, whether it's the EPA or the CIA or the FBI or the Social Security offices or DHS, or pick the thing, pick the organization, including HOAs. And here's what they're doing, is that these people are having to spend $1,000 a year to park down the street, and I didn't show it to you, but basically a mile away. And then they have to walk back over here. Back to their house, they have to walk a mile. What if that person had a knee injury? What if she has a wheelchair problem? And so, by the way, wheelchair accessible vehicles are vans. And they actually said you can't have those kinds of things in your particular facility. Your house, your own private house. This has been the craziness of the systems. And this is the part that I want you to see. All this stuff is getting broken down. And you're going to see lawyers, they're going to have to live within the law, because what they've been doing is throwing in precedent. The precedent of a Chevron defense. So the precedent is this and this, and they're arguing back and forth. And then we, the normal people, go, well, I can't quote that precedent versus that precedent. And then the judge gets influenced by the precedent because he went to law school with her, right? And she went with her best friend, and so they could keep coming up with this kind of stuff. And then we have to have these lawyers interpret the precedences instead of having laws that any one of us can read And we look at the law and it says you cannot restrict a person from having their vehicle in their driveway of any type. You can't do it. And yet these HOAs are out there doing something and violating the Chevron defense. You see, these people feel like, well, rules and regs, I got to live with them because I was involved with it. And the answer is no, you don't. This is going to change so much in the near future when people understand that the power is in the people. This is what Donald Trump talks about. When we see the NESARA thing flip over, you're going to see people talk about this over and over again, and we're going to see these HOAs getting knocked down inside, kicked in the teeth because of what they've been doing. I'm saying figuratively, metaphorically. I'm not talking about going and kicking someone in the teeth. Don't get me wrong here. Don't even think I'm saying that. But when HOAs utilize their power over people and shove rules and regulations and here's the interesting things. They put liens on your house. So if you have to suddenly move, they'll say, well, you have not, done this or done that. Give you a perfect example. It was 1999. We were in a town called Parker, Colorado. And we had a house. And the house was a great house. There was nothing wrong with it. And then we got this sudden lien against us because we're selling the house. We're moving out to a place called Highlands Ranch. And we're moving to the house. And they go, you can't sell the house. Why not? Because you got to get up there and paint this little tiny boxed area that is, it's an air intake kind of spot where the attic gets some air. And I looked at it, I'm like, what? I'm looking up there going, I don't even notice what you're talking about. Well, it needs to be painted. So I had to borrow someone's ladder, go buy some paint, and paint the dumb thing before I was allowed to sell the house because the title wouldn't be released until the lien was released. This is the power of, and what these are is these little Nazi kind of people pushing out these little doctrine points. And this is the cool part that you're going to see. You're going to see agencies, whether they're state or federal agencies, you're going to see these HOAs and these other rules-based things have to follow constitutional laws or laws that are specifically passed in the states or in the federal ones because they're challengeable by the court systems. When you have the balance, the correct balance in the bicameral situation, you have the Congress, Senate, which is the House, right? Or the Congress, which is House and Senate, presidency, that executives, has the executive power of it, has the enforcement of it, and then you have the courts that go, you know what, is it constitutional in nature? When you have that three-prong fight with one another to make sure that when you pass something, it is legal and it is challengeable with that. Whereas right now, we've had these Chevron doctrines of rules and regulations that are just capricious against people. That kind of thing is going to die in the pit of hell. And we're going to see that kind of stuff happening. And you're going to find out that's one of the coolest parts of the NESARA piece. I hope that helped you out and give you a little understanding. You can go to drscottyoung.com and you can kind of download some interesting information in there. Has an outline of NESARA that explains it a lot further. Thanks so much.